Many workplaces, they take real pride in their benefits packages, their employee policies. They look good on the surface. But are there hidden legal dangers lurking just beneath? Things we're calling workplace time bombs that could detonate as we head through 2025 and into 2026.
That's exactly what we're digging into today.
Okay.
And for this deep dive, we've pulled some really crucial insights from a panel of, frankly, top-tier experts. We've got Yesenia Perez, she's the Northeast Compliance Leader at USI.
Right.
Denise Fior, Partner and NJ Employee Benefits Practice Leader, also USI. And Louis Lessig, a very sharp labor and employment litigator from Brown and Connery.
A great lineup.
Absolutely. So our mission today is really to guide you, the listener, through this complex intersection of benefits and employment law. We want to highlight the things employers absolutely need to be watching out for right now.
And one of the key things that came out of that discussion, something Louis and Yesenia really hit on, was this idea that employees, fundamentally, they care most about what happens to them individually.
Yes. That sounds simple, but it's profound.
It really is. Because it exposes this vulnerability, right? That generic one-size-fits-all approach to benefits communication, that's a ticking time bomb.
Exactly. It fuels what they call the marriage between the benefit nightmare and the employment nightmare.
Oof. That sounds serious.
It is. Because if benefits aren't communicated well or they're misunderstood, that leads straight to legal challenges. It's not just confusion, it's liability.
Okay, so let's unpack that. When employers first come to these experts, what are the big worries? What's top of mind?
Well, the big three always seem to surface: cost, compliance, and wellness.
Right, the classics.
Yeah, and it's interesting. Compliance used to feel like, I don't know, a bit of a bad word, but now it's front and center. Still makes people nervous, though. You can feel it.
Understandably. So, looking back over the last, say, 2 years, what did the experts say has changed the most dramatically when it comes to legal risk?
Oh, hands down, the remote workforce. It's been a massive disruptor.
How so? Specifically?
Well, think about it. Remote work hits payroll practices hard, and it messes with the employee's legal home base, their CETUS, as it's called.
CETUS, right, like where they legally reside for work purposes.
Exactly. So if someone working for a New York company moves to New Jersey, or maybe they don't even tell HR and they pop down to Mexico for a few months.
Uh-oh.
Yeah, their status shifts. And instantly you've got new state laws, new tax obligations that the employer might not even know about. It's a huge compliance headache waiting to happen.
That story about the Michigan employee moving to Fort Lauderdale without telling anyone? Wow. That really drives it home. It's not just about tracking locations, is it?
Not at all. It's this whole ripple effect, unexpected compliance issues, security concerns. You mentioned HIPAA data on public Wi-Fi.
Or even just getting a company laptop back from another country.
And the tax nightmares.
Yeah.
It gets complicated fast.
So remote work is a big one. But what else is really keeping these experts, particularly someone like Louis Lessig on the employment law side, up at night?
Retaliation. The rise in retaliation issues is just alarming.
Okay.
Louis really hammered this point. It's not just a side issue. It's becoming one of the most costly liabilities employers are facing right now.
And the numbers back that up, don't they? I think the stat was in 2024, more than half of all EEOC charges had a retaliation component.
That's right, over half. And think about the money of the over $700 million the EEOC got in settlements and judgments in 2024. More than half of that was tied to retaliation claims.
Wow, that's staggering.
It really is. So when we talk about these ticking time bombs, we're not talking small stuff.
No.
These are potentially massive financial and reputational hits for companies.
Okay, so given all these potential landmines, the experts were asked a great question. If you could wave a magic wand, fix just one thing before 2026, what's the priority?
Right.
What did they zero in on?
The employee handbook. Almost unanimous on that one.
The handbook? Really? Seems basic.
It seems basic, but that's why it's such low-hanging fruit for problems. So many are outdated.
How so? Like old information?
Exactly. Still mentioning COVID protocols maybe, or vaccination requirements the company doesn't even have anymore, or listing benefits that have changed or expired.
Ah, so you could be accidentally promising things you don't offer.
Precisely. Or, maybe worse, you're missing crucial legal language that protects the company in a lawsuit. Plus, they take a long time to redo properly and leave policies within the handbook, often totally out of date or just plain wrong. It's a foundational document, and if it's wrong, a lot else can go wrong too.
Makes sense. Now, what about the elephant in the room, something that's really changing the game right now?
AI, artificial intelligence. That came up immediately.
Of course. How is that playing out in the HR and benefits world?
Well, you've got examples like IBM apparently cutting a significant number of HR roles and replacing them with AI agents. That's huge.
Yeah, that's a major shift.
But it's this double-edged sword, right? AI offers incredible efficiency, sure, but you absolutely need clear policies to manage its use. Remember that Samsung developer?
The one who put proprietary code into a public AI chat?
That's the one. Nightmare scenario for any company. You need rules. And there's even this background concern about, like, the actual power grid. Can it even support this massive AI expansion?
Wow, that's a whole other level of concern. Infrastructure.
Yeah. And this brings up another point Louis Lessig made. Some employers think, maybe counterintuitively, that not having a handbook is safer. Like, less documentation, less liability.
Is that true?
Not really, it's a myth. Okay, maybe you don't need a fancy-bound handbook, per se, but you absolutely need comprehensive policies, standard operating procedures, SOPs. And they must be documented and accessible.
Right.
Lou had a great line. He said, when lawyers ask for an employee's file in a lawsuit, including email trails, you should be able to hand over a terabyte of information. If you can't produce clear, documented policies and procedures, you're in trouble.
A terabyte. That paints a picture.
Yeah.
So how does this connect to the actual benefits plan documents? Yesenia and Denise must see issues there too.
Oh, absolutely. Plan documents vary a lot depending on group size, right? Under 50 employees, 5099, over 100, especially in states like New Jersey with specific rules.
And the documents from the insurance carriers themselves aren't always enough.
Often, no. They can be pretty generic. They might lack the specific ERISA language you need, especially if you're subject to ERISA, which most private employers are.
Okay, ERISA, the federal law governing benefit plans.
Right. And for larger employers, say over 100 employees, Yesenia highlighted something called wrap plan documents.
Wrap documents, what's that?
Think of it like this. Instead of having separate plan documents and separate filings, like Form 5500s, for your medical, dental, vision, life insurance, etc.
Which sounds like a lot of paperwork and potential for error.
Exactly. A wrap document bundles them all together under one umbrella plan document. It simplifies administration, but the big win. It can cap your penalty liability for those 5,500 filings. If you mess up, it might be treated as one plan failure, not 5 separate ones. Huge potential savings on penalties.
That sounds incredibly useful. Smart planning.
Definitely. And then there are specific documents people often miss. Section 125 plans, cafeteria plans.
For pre-tax benefits, right? Medical, dental.
Yep. Your pre-tax deductions. Now, the IRS might not be knocking on doors every day to audit these specifically, but as Yesenia pointed out, it's an easy thing to fix. And with government agencies getting more funding for audits, why leave yourself exposed?
That's the point. Get ahead of it.
And they shared a real-world example. A woman's husband passed away, and she wanted to change her benefit elections. But the plan document, as written, didn't allow it because she wasn't technically losing coverage under his plan.
Oh, wow. That seems harsh. But it highlights the need for precise language.
Exactly. It's not about being heartless. It's about having policies that are clear, legally sound, and updated. It also busts a common myth. Employers don't have to allow changes for every single qualifying life event, only the federally mandated ones like birth, marriage, loss of other coverage, CHRO Medicaid eligibility.
Got it. So you have some flexibility, but it needs to be documented.
Precisely. And things like HSA-compatible plans, they absolutely need specific language in the plan document, too. Can't just assume it's covered.
Okay, let's shift gears slightly. Critical pitfalls in specific benefits. COBRA came up strongly.
Yes, COBRA administration, the experts, particularly Yesenia, were very direct. Outsource it.
Outsource it. They called it low-hanging fruit.
Yeah.
Inexpensive.
They did.
Now, I can hear some HR folks thinking, great, another vendor, another cost. What's the compelling argument to get past that? Why is outsourcing COBRA so critical?
Because the cost of not doing it right is potentially catastrophic. It's pennies on the dollar compared to the liability.
How so?
Outsourcing ensures those COBRA notices actually get mailed properly, with proof of mailing, not just stuck on a bulletin board or emailed vaguely. This protects you if someone later claims they never got notice.
Okay, proof is key.
Absolutely. And it prevents claims being denied down the road because someone wasn't offered COBRA correctly. They gave this chilling example. Someone was mistakenly left on the active employee plan for 3 years after they should have been offered COBRA.
3 years.
3 years. Then they had a $1 million medical claim.
Oh, no.
And the claim was denied because they were ineligible, they should have been on COBRA, but because the employer never offered it correctly. Huge liability. That's that marriage of the benefit nightmare and the employment nightmare right there. An admin error becomes a legal catastrophe.
And potentially class action lawsuits, too, right?
Definitely a risk. COBRA mistakes are ripe for class actions.
And connecting this to the bigger picture, especially for older workers,
Yeah.
there's that tricky interaction between COBRA and Medicare.
Oh, that's a minefield.
Yeah.
Major planning issues, major complications.
Explain that primary-secondary thing again.
Sure. So generally, if an employee is actively working and has employer coverage, that plan pays first its primary, Medicare is secondary. But once they stop working and go off the group plan, maybe onto COBRA, maybe not, Medicare typically becomes primary.
Okay.
The problem is many older employees don't understand when they need to sign up for Medicare Part B, especially if they're still working past 65. If they miss their window, they can face lifetime penalties and huge gaps in coverage. Essentially, very low coverage when they need it most.
That sounds awful for the employee.
It is. There was an anecdote about a business owner who personally messed up their Medicare enrollment, picked the wrong thing, and it took a year to untangle. Imagine that happening to your employees.
So employers need to guide them.
Well, they need to be careful not to give advice, but providing clear information and resources is crucial. And Louis Lessig added a key point. Always include COBRA information clearly in separation agreements. Get it documented up front.
Smart. Okay, moving from leaving employment to taking leave. Leave policies. Post-COVID, lots of employers added their own extra leave, right? Like enhanced parental leave beyond FMLA.
Yes, definitely a trend. More generous leave policies.
Sounds great for employees. What's the hidden risk for the employer there?
The risk lies with the insurance carrier. If an employee is on a company-granted leave that extends beyond FMLA protections, the insurance carrier might deny claims disability, maybe even health claims, arguing the person isn't technically eligible under the standard policy terms.
Whoa. So your generous leave policy could backfire.
It could, unless you've proactively talked to your carrier and gotten alignment. You need to make sure your insurance policies explicitly cover these extended employer-specific leaves.
Like that example of the client wanting a full year of parental leave.
Exactly. The carrier agreed to most of it, but drew the line at life insurance that had a 90-day limit during leave. The key was communication. Making sure the carrier agreed, documenting it, and clearly telling employees the specifics. Ensuring, as Denise Fear put it, the 4 squares of your document are protecting that leave.
Got it. And what about when FMLA runs out, but the employee still isn't ready to return, say for a medical reason?
Then you're likely looking at the ADA, the Americans with Disabilities Act. This triggers the need for an interactive process.
That sounds formal.
It is, and it's legally required. It's not just a quick chat. The employer must engage with the employee to discuss their limitations and explore potential reasonable accommodations that could allow them to return to work.
And managers sometimes drop the ball here.
Easily. A manager might just say, oh, okay, let me know when you're better. You know, that sort of, response. That's not the interactive process.
Yeah.
Failing to engage properly is a huge ADA compliance risk.
Okay, let's pivot one more time. Social media. This area feels like it's constantly shifting.
It really is. There's that anecdote. People do stuff at work they would never do at home in front of their family.
Probably true. But from a legal standpoint,
It gets complicated fast. Think about religious accommodation cases stemming from social media posts. Like that Southwest Airlines case, an employee fired over pro-life posts, sued, and won. Employers have to navigate very carefully.
and now with AI, deepfakes, generated content, how do you even know if it was your employee who posted something controversial?
That's the emerging nightmare. Authenticity. Is it really them? Louis Lessig put it well. Employers need to step back and figure out what they are really trained to manage and monitor and protect from. You can't police everything.
So the policy needs focus.
Yes, and it absolutely has to be tied into your existing harassment and discrimination policies and procedures. Online behavior can easily create a hostile work environment or constitute harassment.
Makes sense. And is there a benefits angle to social media too?
There is, yeah. Think about company culture. Your social media presence reflects that. But be careful what you promise or brag about.
How so?
Say you excitedly announce a fantastic new fertility benefit on LinkedIn. Great PR, right? But what if the budget gets tight next year and you have to scale it back or cut it?
You've created an expectation.
Exactly. You might feel forced to keep offering it even if it's not sustainable because you publicly committed. Any policies you share proactively, especially online, get legal counsel to review them first. Manage the perception carefully.
Good advice. Okay, we've covered a ton of ground handbooks, remote work, retaliation, COBRA, leave, AI, social media. So how do we pull this all together? The experts tackled two key questions near the end. First, how can HR better align benefits and pay to avoid these compliance gaps?
The answer really came down to proactive conversation and collaboration, breaking down silos.
Talking to each other internally.
Yes, but also externally, especially critical during things like mergers, acquisitions, or spin-offs. You need benefits, HR, and legal all talking to prevent major missteps, like accidentally creating a multiple employer welfare arrangement, a MUWA.
That sounds bad.
It can be very bad. UNWs often require Department of Insurance approval and have complex compliance rules. Stumbling into one unknowingly is a serious issue.
So working with attorneys is key.
Absolutely. Louis Lessig made it clear, I can tell you what the law says, but I can't tell you personally exactly what to do with your business. You need that collaboration. And then he dropped that very direct line.
The pay me now or pay me later one.
That's the one. You have two choices. You can pay me now or you can pay me after the lawsuit's filed. You're way better off to do the front end because it will be much more economical for you.
Blunt, but probably true. Which leads to the second question. How do you message these liabilities to leadership? Because getting buy-in for preventative measures can be tough.
It really can. The key takeaway was that the messaging has to be handcrafted for the audience.
Meaning?
Your CFO cares about the potential sticker shock, like that $2 million denied stop-loss claim example due to a COBRA error. That gets their attention.
Right, the bottom line.
But your CEO, maybe they respond more to the idea of keeping employees happy, avoiding bad press, maintaining morale. You tailor the message.
And what about that internal struggle HR often faces, like getting budget for supervisor training to prevent retaliation?
That's a classic example. HR knows the training is crucial, directly linked to reducing costly retaliation claims. But leadership might see it as just another expense. Framing it in terms of risk mitigation and cost avoidance is key.
And sometimes bringing in an external expert helps get that message heard.
Often, yes, it adds weight. And that's also where things like benchmarking come in. USI, for instance, has massive amounts of benchmarking data.
How does that help?
It ensures you're offering competitive and appropriate benefits. The right plans, the right actuarial value differentials, the right employee contribution strategies, as Yesenia put it. It provides objective data to support your recommendations to leadership. And crucially, using current data, 2025 data, not last year's report, to make informed decisions for the future.
So, wrapping this all up, our deep dive today really underscores that vital, almost inseparable link between benefits administration and employment law compliance.
Absolutely.
We've seen the scary rise in retaliation claims, the absolute necessity of keeping handbooks and all documentation current and comprehensive. We've touched on the tricky risks with COBRA and Medicare transitions and the complex, evolving challenges coming from AI and social media. Vigilance seems key.
It really is. And maybe a provocative thought for you, the listener, to take away. We're in an environment where federal agencies are being directed to increase audits. State laws are getting more fragmented and complex every year. So how confident are you that your organization isn't, perhaps unknowingly, sitting on one of these ticking time bombs?
That's a sobering question.
It is. What's the one proactive step you can take this week, this month, to start connecting the dots between your benefits and your employment practices, to make sure you're diffusing potential problems before they explode?
That's the crucial action point. And if these issues we've discussed today are hitting home, if you want to get ahead of these potential workplace time bombs, definitely consider reaching out to the experts we've been drawing from Louis Lessig at Brown & Connery for the employment law side.
And Yesenia Perez at USI for benefits compliance.
Right. They even mentioned offering complimentary reviews of benefit summaries or guides and providing benchmarking insights for clients and prospective clients. A great way to get an expert eye on things.
A really valuable first step.
Absolutely. Well, thank you for joining us on this deep dive. We hope it's given you valuable insights and practical things to consider. Stay informed, stay proactive,